to mention item number 4 for accommodating today, my lord. I have mentioned the slip also, yes.
On request made by Ms. M.
Ember.
Then the make the story. It is the matter after
1 week, my lord.
2 weeks.
Obliged.
May I please your lordship? Lordship, I apologize. I could not give the adjournment slip yesterday, my lord, with regard to item number 5. My lord, 5. Can this matter be adjourned, my lord? Can this matter be taken up on, my lord, after some time, on 15th of June? I have taken consent of the opposite. Can
Yes, she told me yesterday, few days back, in fact, but she didn't give the adjournment slip.
yesterday, my lord, I missed out. Actually, I forgot out of like I forgot.
Your Miss
S.G. Borua.
on request made by Zara, then the council to the applicant.
My lord,
When
can it
do
be on 15th of June? It's a Thursday hearing.
Matter on 15th.
My lord, I have another mention, my lord, with regard to a matter for listing in orders. Orders, can it be on Monday, my lord? For orders.
Witness.
My lord, when is the window? Must oblige, my lord.
May I please, Your Worship, may I pray for listing of an IA, my lord, of a criminal appeal, my lord, which was listed already admitted, my lord. Can it come on the next week, my lord? For others. Oblige me.
Item 1 of the.
May it please your lordship, my lord. My lord, this is a 389 petition for suspension of the sentence where the petitioner is undergoing a sentence of 12 years. 12 years was the total quantum of sentence awarded to the petitioner, my lord. And he was convicted under this Commercial Quantity NDPS Act, 25 kg of ganja, my lord, section 20 B2C. Now, my lord, on the last occasion,
1 minute.
my lord.
Antecedent report.
Lordship is perhaps going through the antecedent report.
Yes.
On the last occasion, Honorable Chief Justice ordered me to bring that report. So that report is before your lordship. I thought I'll tell when my turn comes. In the report, it's written, apart from this case, perhaps, he is otherwise a businessman. He has no connection with other cases. What it says is, except reference case number 451 of 21. 451 of 21.
The present case.
451 of 21 is the instant case. 451, where is it, Richard?
FIR. Kindly come to.
Yes. Bongaigaon PS case 451 of 21. Apart from that, it is said that he has no past history of any criminal cases. This is what the anticipate, because last order, lordship will see, Honorable Chief Justice has called for that report.
My lord, I will prima facie demonstrate, my lord, that this is a case where the FSL report does not relate to the seizure in question. That is the end of the story, man. My lord, this is a small compilation of the evidence and the exhibits. I have paginated the same. I will just demonstrate to your lordship that the alleged contrabands which have been, according to the prosecution, seized from the house of the petitioner, in his absence, it is only 25 kg of ganja, my lord. The 25 kg of ganja, the samples which was drawn was not the sample which was sent to the FSL. Therefore, the FSL report does not relate to the sample in question. My lord will kindly come to page number 12 of my compilation, my lord. Page number 12. This is the person who has prepared the sample, because sample was prepared in the CGM court as per the direction of the Honorable Apex Court in Mohanlal's case, my lord. The Supreme Court has said that samples has to be drawn before the magistrate by interpreting section 52 capital A subsection 2. So, my lord, page number 12, my lord, para number 2. I prepared 3 sample packets containing 25 gram each. From those 3 packets marked as A, B, and C. The sample packets were marked as A1, B1, and C1 and sealed with the facsimile seal CGM Bongaigaon. My lord will kindly mark the facsimile seal. CJM Bongaigaon. So this will identify the sample in question, this seal, my lord. Now, my lord will kindly come to page number 19. This is the scientific officer who received the sample and who tested the sample, my lord. On 25/5/20, I was working as scientific officer at Directorate of Forensic Science, Assam, Kahilipara, Guwahati. On that day, I received a parcel from the divisional in charge in connection with Bongaigaon PS such and such. For example, the parcel was consisted of 3 exhibits enclosed in a seal envelope covered, and the facsimile of the seal was found to be Superintendent of Police Bongaigaon. Matter ends there, my lord. The sample in question was sealed as, the facsimile of the seal was CGM Bongaigaon, but the samples which were received in the FSL contain the seal Superintendent of Police Bongaigaon. How can this be, my lord? The very sample goes.
Yes.
Now, my lord, for 389, my lord, this is my first limb of argument, my lord. Now, my lord, if I understand the procedure of under the NDPS Act, then the procedure of search and seizure is this. My lord, the section 42 deals with search and seizure if the police has prior information. This is a case of prior information. This is the case which has been built up in here is that they have prior information that some ganja were there in the house of the petitioner. Now, when such, in a case of prior information, a person, a gazetted officer will have to authorize a person for search and seizure. The authorization has to precede search and seizure. Number one, my lord. After the search and seizure, the contrabands has to be kept in the police station. It has to be kept in a malkhana with a proper entry in the registered. That on such and such date, such and such quantity of contraband entered the malkhana. And the malkhana register has to be signed by the malkhana in charge. Then when the contraband is taken out of the malkhana, there has to be an entry. Because, my lord, with all humility, my lord, what I am submitting is that under the NDPS Act, the court has said that the more stringent the punishment is, the more strictness of proof is required. Because it is a stringent act, so we cannot be flexible in compliance. It has to be scrupulous compliance, my lord. Therefore, my lord, the law says that since the provisions are stringent, therefore you will have to follow the safeguards provided under the Act scrupulously. Not substantial compliance, but strict compliance. That is the term used by the Apex Court, my lord. Be that as it may, my lord. Now, here is a case where they do not examine the malkhana in charge because the very sanctity of the sample was compromised. The entire case is built on the sample, my lord. The malkhana register has not been exhibited. The malkhana in charge was not been examined. Thus, we cannot say under whose custody the samples were till it was sent to the FSL. We cannot say that whether there was any malkhana in charge who was guiding the samples, my lord, was guarding the samples. My lord, the 3 independent witnesses cited by the prosecution in their cross-examination says we do not know from where this has been recovered and they are not declared hostile. My lord will kindly come to the compilation, page number 1, that is projected to be an independent witness, page number 1. His name is Bijoy Ray. My lord will kindly see cross-examination. The first line in the cross-examination. I have not seen from where police seized the ganja. My lord will kindly come to page number 3, the second independent witness, Pradeep Burman. My lord will kindly see his cross-examination, page 4, the second line. Cross-examination, page 4, the second line. I have not seen, the second sentence, in fact, I have not seen from where police recovered the suspected ganja. My lord will kindly come to page number 5. The third independent witness. He was inquired after about 5-6 months of the incident. So he does not, his evidence does not help the prosecution in any manner. After 5-6 months of the incident, I know Bonamali, his vehicle is on rent. Police inquired me after about 5-6 months of the incident. Then PW4. The other independent person. I know Bonamali gives his vehicle. Police inquired me about 5-6 months of the incident. I do not know from where police recovered ganja. These are the independent witnesses which the prosecution has adduced in support of their case. All the independent witnesses unequivocally deposed before the court that we do not know from which place the ganja was seized. Now, my lord, and out of these 4, my lord, the witnesses, PW1 and PW2 happens to be the seizure witness. They are independent seizure witness, PW1 and PW2. So the seizure witness discredits the prosecution case, my lord. Now, PW5 was a member of the raiding team, my lord. On 21/5/2021, I was posted as PSI at Bongaigaon PS. On that day, I received secret information that Bonamali Sarkar of such and such is involved in selling ganja at his house. I informed the matter to OC. He informed the matter to higher authority by making GD entry number such and such, dated such and such, and informed that DSP will give authority at the place of occurrence. Exhibit 2 is the extract copy of the GD entry number 685, dated such and such. Such Exhibit 2(1) is the signature of the then OC Bongaigaon, such and such, which I know. OC Bongaigaon PS made a team, including me, and we proceeded to the place of occurrence with investigation kit, digital weight machine, and seal at 7:30 p.m. At 7:45, we reached such and such and met source person. We went to the house of Bonamali Sarkar as shown by the source. Before entering the house of Bonamali Sarkar, 2 local persons were asked to accompany us and they agreed. They were also asked to check our vehicle and our body. They denied. At 8 p.m., we entered the premises of Bonamali Sarkar. In the meantime, OC Bongaigaon and DSP headquarters appeared there. Gayatri Sarkar, wife of Bonamali Sarkar, come out of the house on being called by us and informed that Bonamali was not at home. At that time, authority letter was given by Amitabh Chaudhary, Amrit Raj Chaudhary, DSP headquarters. Exhibit 3 is a copy of the authority letter. We started house search from 8:10 p.m. We found 9 packets containing suspected ganja from an adjacent room in the backside of the house, and one yellow cement packet containing suspected ganja from the garage, which was kept inside a spare tire. We collected all the recovered suspected ganja and brought to the front courtyard of the house of Bonamali Sarkar and weighed each packet in presence of witness DSP and such. The overall weight of the ganja were found to be 25.53. The recovered suspected ganja were seized. Wide seizure list. Exhibit 1, Exhibit 1-2 is my signature. All the recovered suspected ganja were unloaded from their respective 10 packets to 3 new packet bags separately, and those 3 packet bags were again weighed and sealed. Now, my lord, I take a pause here. The contrabands were tampered. 10 packets were made into 3 packets. They ought to have bought the contraband before the CGM and then drawn the samples. But before that, they have opened the seal, 10 packets made into 3 packets. In presence of witness, the weight of the 3 new packets was found to be the same as 25.53, 25.563. Signature of the witness were taken on the marked A, B, and C marked packets. Seizure witness along with the wife of Bonamali Sarkar were examined and their statement under section 161 CRPC were recorded. At 9:40 p.m. we left the place of occurrence along with the seized article. At 10 p.m. we reached the police station. OC Bongaigaon prepared inventory of all the seized articles. As per seizure list, the seized articles were kept in Malkhana. Where is the Malkhana register, my lord? On the next day, such and such. They don't exhibit the Malkhana register. They don't name the Malkhana in charge as well. And moreover, the person who carried the samples, the messenger who carried the sample to the FSL was not examined. So that he could have connected the sample collected in connection with the instant case with the sample that have reached the FSL. The only connecting link was the messenger. That messenger has not been examined. And admittedly, there are two facsimils found. One affixed on the samples and the other found by the forensic laboratory expert. Now, my lord, whatever he has deposed before the court, these are all afterthoughts. Why I am making this submission? Because my lord will see in the cross-examination, he does not state so many things in her statement under 161. 161 statement, my lord, if I understand correctly, is recorded at is more contemporaneous in time. 161 is more contemporaneous in time because it is recorded immediately after the incident. We come to court after 2 years or 3 years. We come to court, my lord. So, my lord, the statement which he made under 161, it does not contain so many details. He is trying to improve his case before the court because appropriate suggestions, he was confronted with his 161 statement and he has admitted that he has not deposed all this before the police. I read the cross-examination part. In the Izahar, the reason for delay in lodging it is not mentioned. Yes, my lord. My lord will kindly take note of the time and the time of this Izahar, my lord. They entered the house on 21/5/2021 at 8 p.m. My lord, may kindly take note of this, my lord. 21/5/2021 at 8 p.m. At 8 p.m. they entered the house. Seizure was made at 8:45. FIR was lodged on 22/5/2021 at 10 a.m. FIR was lodged on 22 next day at 10 a.m. And it was sent to FSL on 23/5/2021. Therefore, from 21 till 23, the samples were in whose custody we do not know. We do not know it was in whose custody. Nothing has been exhibited to satisfy the court that the sanctity of the samples were not compromised. Nothing on record. Yes, my lord, coming to this, in my statement under 161, it is not mentioned that I have given written authority letter before search of the place of occurrence by DSP. In my statement under 161, it is not mentioned that I was given written authority letter before search of the place of occurrence. In my statement 161, it is not mentioned that I conducted a search in the presence of 2 local witnesses as it was night at that time. In my statement under 161, it is not mentioned from which part of the house of the accused the suspected ganja was recovered, and the number of the packets suspected ganja recovered is also not mentioned. In my statement under 161, it is not mentioned that suspected ganja were seized and samples were prepared. In my statement under 161 CRPC, it is not mentioned that I informed the matter to the OC. My lord, I'll just keep, he denies everything. He has literally stated that I have not stated any of this which I have stated in my examination in chief before the IO in my 161. He has admitted that it is not mentioned. The moment 161 statement he was confronted with when he was in dock, he has said that yes, it is a fact that I have not mentioned all these things. I have not mentioned. Therefore, my lord, what this council is humbly submitting is that these are afterthoughts. 161 is more contemporaneous in time. It is recorded immediately after the incident within 1 or 2 days, my lord. And this has been recorded. Incident is on 21/5 and this statement was recorded on 24 May 2022. After 1 year. So he became wise after 1 year. He remembers everything, but he doesn't remember all these things when 161 was recorded probably within 1 or 2 days. But suddenly his memory became so sharp after 1 year. Because then they have done all this homework that yes, missing link they will have to add. So he's deposing all these things. He was rightly confronted with his statement under 161 and he has admitted that I have not stated any of these things in my 161. Same is the case. And PW6 is the person who has, who has made the sample packets. That is the peon of the CGM, because the samples were produced before the CGM, and in the presence of in the CGM court, these samples were drawn. Because initially, my lord, under the 1989 standing order, samples had to be drawn on the spot. But that standing order was put to challenge in Mohanlal's case in 2016. In 2016, the Supreme Court has held that part of the standing instruction which relates to drawing of sample on the spot as ultra virus. And the Supreme Court has said that samples has to be drawn in the presence of the magistrate in view of the mandate of section 52, capital A, subsection 2 of the NDPS Act. So therefore, my lord, they draw the sample in the presence of the magistrate. And this is the man who has drawn the sample, page number 12, my lord will see. I work in the office of the CJM Bongaigaon on 22/5/2021 at about such and such PM. Bongaigaon police personnel brought suspected ganja in 3 packets. I prepared 3 sample packets containing 25 gram each from those 3 packets marked as A, B, and C. The sample packet were marked as A1, B1, and C1 and sealed with facsimile seal CJM Bongaigaon. He has prepared the sample and the seal which he has affixed on the sample packets was CJM Bongaigaon within inverted comma capital. The sample packets were handed over to the IO for sending to FSL for forensic examination. Now, he says, I have not stated before the police that I prepared 3 sample packets containing 25 gram each from those 3 packets marked. The sample packets were marked as A, B, C and sealed with which he again confirms in his cross-examination that it is sample packets were sealed as CJM Bongaigaon. Then, my lord, PW7 is another peon of the CJM court. Same thing, more or less, my lord. I'll skip this, my lord. PW8, my lord, investigating officer is PW8. So before I go to the investigating officer, my lord, I'll just finish off the other one small evidence at page number 19. That is the FSL, the person from the FSL, page number 19. I'll just. On 24/5/2012, I was working as scientific officer at Director of Forensic Science, Assam, Kahilipara, Guwahati. On that day, I received a parcel from divisional in charge in connection with Bongaigaon PS such and such. For example, the parcel was consisted of 3 exhibit enclosed in a seal envelope cover, and the facsimile of the seal was found to be Superintendent of Police Bongaigaon. The 3 samples, description of the 3 samples, 25 gram of dry plant on careful examination, United Nations drug test, all these things. Positive test of cannabis, that is ganja. My lord will kindly juxtapose this part of the evidence with the FSL report, which is at page number 49. My lord is there at page number 49, my lord.
Yes.
Yes, my lord, even my purpose in drawing attention of your lordship to this page is to show that even what he has deposed corroborates with his report. The facsimile of the seal was found to be Superintendent of Police Bongaigaon. My lord may kindly take note of that, my lord. Even in this report also, it is not that in the report it was CJM Bongaigaon and before the court he has deposed something else. Precisely what is there in the report, because he is a neutral person. He is from the Directorate of Forensic Laboratory. He will not take the side of the police or the side of the accused, my lord. Now, the IO, my lord, that is at page number 15, PW8. On 22/5/2021, I was posted as attached officer Bongaigaon PS. On that day, I was endorsed to investigate Bongaigaon PS case number 451/2021 under section 20C NDPS Act as per FIR lodged by such and such. Exhibit such and such is the FIR. Exhibit such and such is the signature. I went to the place of occurrence and prepared separate sketch map of the place of occurrence and kept in CD. Exhibit 5 is the sketch map. Exhibit 5(1) is my seizure. I recorded the statement of witnesses and informant. I searched the accused, but he was not found. On that day, I made prayer before the Honorable Court for seeing the original seizure list as well as the exhibit MR number such and such in connection with the said case. Exhibit such and such is my prayer. Exhibit such and such is my signature. Exhibit such and such is the signature of the IC, CGM, such and such. Inspector Jyoti Lahon prepared inventory of the 3 numbers of packets ganja. Now, inventory was prepared. My lord will kindly take note of this. 10 packets were recovered. Inventory was prepared of the 3 packets which they have. I do not know how they have mixed it. They should not have tampered with the contrabands. It was the prerogative of the Chief Judicial Magistrate. Their job was to bring it before the Chief Judicial Magistrate, and then whatever unpacking has to be done, it has to be done there. Whatever sample has to be drawn, it has to be drawn and packed in front of the CGM. They have absolutely not respected the sanctity of the contrabands. Inventory of 3 numbers of suspected ganja packets seized by such and such, such and such. On the day of incident, that is such and such, Exhibit 7 is the inventory report. Exhibit such and such is the signature of the then OC, such and such. Inspector such and such made a prayer for certification of the correctness of inventory, permits for taking photographs of the seized items in connection, and certified such photographs as true and allow for drawing of representative samples in presence of court. And certify correctness of the list of the samples to draw. Exhibit such and such is the prayer of the inspector. Exhibit such is the signature. Exhibit such and such the signature of the CGM, such and such. I, being the IO of the case, shown the prayer to the inspector Jyoti Lahon and the inventory before the court. As per the prayer made by the inspector Jyoti Lahon, Honorable Court allowed me to collect sample of the seized articles in her presence and certified the correctness of the inventory prepared by the OC. Accordingly, 3 samples weighing 25 grams each were drawn and marked as such and such from the same 3 packets of suspected ganja. After drawing samples, remaining ganjas were sealed and marked as ABC. Photographs of the samples and seized ganja. Exhibit 9 is the order passed by the Honorable Court. The then CGM is by signature. Exhibit 10 is the photographs of sample. Exhibit is the signature. These are all exhibits, my lord. I made a prayer for the Honorable Court to sending the sample to FSL. Prayer, it is my prayer, this is my signature. I informed regarding seizure and recovery in writing to the Superintendent of Police, Bongaigaon. Exhibit 13 is the information. Exhibit 13(1) is my signature. The information letter was shown before the Honorable Court, such and such. I have shown the copy of the authority letter issued to SI Kuldeep, such and such is the signature of the. Now, my lord, this authority letter which he is speaking, your lordship will find it at page number 30. This authority letter, I searched in vain, my lord. I could not find the time. Why time is important here, my lord? Date will not suffice. Because it had to precede the search. Playing safe. Put the date. These are all backdated prepared documents. And therefore, none of these were stated before the IO. This does not contain any time. It has to contain time. I'll take your lordship to the relevant provision under the NDPS Act.
Authority letter is what day, page
3030.
48.
30. Yes. So I, being the IO of the case, has shown the prayer as per the prayer of the. This is I skip. Page number 17, I am reading. Samples were sent to the FSL Guwahati. My lord, these all skipping. For chemical examination through a forwarding letter, SP along with an authority letter to break the seal of the sample in hand in CB is the forwarding letter, is the signature, authority letter, seal of samples is the authority letter. I closed the CD being busy with law and order duty. Accused was arrested by Krishnandu Pathak. He collected the FSL report. Exhibit 17 is the FSL report, such and such on completion of the investigation submitted by SI, such and such against the accused. Exhibit 19 is the charge sheet, the signature. Now his cross. The reason for delay in lodging is no mention. Extract copy of GD entry is not submitted along with charge sheet. I have not recorded the statement of the then OC Jyoti Lahon Borgohain. Additional SP Borgohain, ABC Girish Chandra Ray, messenger and cameraman. The messenger was Girish Chandra Ray who carried it. He was not examined. Informant did not state before me that he informed in writing about secret information and copy of GD entry to superior officer. that he was given written authority letter before search of the place of occurrence by the DSP. I take a pause here. That was precisely my argument, my lord. In 161, he has not mentioned about any authority letter. It is all what they are trying to improve before the court. This is clear admission that he was given. Informant did not state before me, then relate to this sentence, that he was given written authority letter before search of the police. Did not inform. That he conducted search in presence of local witness. Even this was not stated before the IO, that he has conducted. And that is the precise reason where they have denied this all these witnesses, that we do not know from which place it was recovered. That from which part of the house and how many packets of suspected ganja were recovered by him. That the suspected ganja were sealed, packed and marked in the place of occurrence. Nothing was stated, my lord. That how much quantity of suspected ganja was taken from which packet at the time of seal and pack. That the suspected ganja was weighed in the presence in the place of occurrence. Extract copy of Malkhana register is not submitted at the time of CG charge sheet. Extract copy of the Malkhana register. I have no knowledge about preparation of inventory. Judicial magistrate was not cited as a witness. It is not a fact that investigation was not done properly. So, my lord, nothing, whatever compliance, little compliance he has tried to he has tried to develop at the stage of trial, nothing was stated by him before the investigating officer. I've already, now one court witness is there, my lord. That is at page number 21. That is the OC Bongaigaon. This was the precise question which the learned trial court asked him, that you have seized 10 packets. How come 10 packet became 3 packet? Now he gave an explanation. On 21/5/2021, I was posted at OC Bongaigaon PS. On that day at about 6:50, based on a secret information, I along with my staff, including such and such and others, went to such and search and seizure was conducted by such and such on being authorized by DSP such and such. At that time of such, 10 numbers of suspected ganja packets were recovered from the house of Bonamali Sharkar, that is the appellant, out of which 1 packet was found to be yellow colored cement bag and the other 9 packet polythene bag. On being measured, 25.536 kg of suspected ganja was recovered. Search and seizure measurement was conducted in presence of witness. After completing formalities, the 10 packets of ganja were packed in 3 polythene packets and marked as A, B, and C in presence of witness. Again, those were weighed and packed, marked as A with such and such. These are the weight of samples, my lord. I made an inventory in this regard. Cross, I have not given written information about secret information as well as extract copy of GD to any superior officer before conducting search. I did not procure any certificate regarding the working condition of the weighing machine. My statement was not recorded by the IO of this case. Such a vital witness and his statement has not been recorded, my lord. It is not a fact that nothing was recovered from the accused, that I did not visit the place of occurrence, that I deposed falsely and I prepared inventory, that I deposed falsely, that I prepared 3 packets of suspected ganja from 10 packets of ganja. For clarity, following points are recorded in question answer form. As deposed in examination in chief by you, 10 packets were seized, but you have made 3 packets for inventory from the said 10 packets. Now my question is that what proportion did you have collected from the said 10 packet for preparing inventory? I received 3 packets containing suspected ganja. Packet marked as A, weighs to be such and such. Packet marked as B, weighs to be such and such, and packet marked as C, weighs to be such and such. No clarity, my lord, from the 10 packets, from which packet, how much was taken and made 3 packets. He is simply saying, he's saying of the later 3 packets, that in packet A, this much quantity, I have packet B, this much packets in this much. The question was 10 packets, how much proportion from each packet you have taken to make packet A, how much proportion from each packet you have taken to make packet B and packet C. He says packet A weight this much, packet B weight this much, packet C weight this much. It is not a fact that I have not prepared 3 numbers of inventory from the said 3 packets for preparing inventory. As to what proportion I have collected from the said 3 packets for preparing inventory, it is not a fact that weighing machine was not in working condition. And then comes the 313 statement, my lord. It is a case of complete denial. Because he gives it, there is, my lord, page number 25, question number 9. Do you have anything else to say? I am innocent. I am totally ignorant about the recovery of ganja. I give my vehicle on rent at FCI Gudam. So, my lord, assuming and not admitting for a moment, if something was found from the backyard of his house, admitted, it has come up in evidence that he gives his car on rent to FCI Gudam. If somebody 25 kg is not a very huge quantity of ganja. If someone has planted, we do not know, my lord, because it was not found from his bedroom, my lord.
No, one packet was found from the garage.
Not exact, my lord.
Garage or?
My lord will kindly come. My lord will kindly
From
come.
the spare tire.
At the time of was also present with me. We show the house of the accused of the police. He was not present with us. His wife was. Police searched the house of the informant. Police seized the ganja. This, my lord, I'll just that part I'll read from the seizing officer's evidence. I'll indicate to your lordship. My lord may kindly come to page number 7.
Third paragraph.
Page number
Spare
8.
tire,
Page number 8, third paragraph. Yes.
third paragraph.
It was recovered from a spare tire.
Was kept inside us.
Inside a spare tire. Page number 8, para 3. We found 9 packets containing suspected ganja from an adjacent room in the backside of the house. Adjacent room in the backside of the house inside a spare tire. And it has come up in evidence that he gives his car on rent. All the independent witnesses deposed this in the FCI Gudam. And my lord, today morning his antecedent report has also come. On surmises, my lord, a person cannot be, my lord, under the NDPS Act, my lord, what we have of late, what is happening is that, my lord, convictions are given on the basis of perceptions, not on the basis of evidence, my lord. It is given on the basis that 25 kg he must be have done. It is perception, my lord. If we dissect the evidence, my lord, to whatever little I understand, my lord, they'll have to prove the prosecution will have to preserve the sanctity of the sample. Everything, the entire edifice of a case under the NDPS Act is based upon the sanctity, purity of the samples. 10 samples without any authority, reduced it to 3 packets, 10 packets, reduced it to 3 packets. Taken before the CGM, peon says, I have put this seal, FSL says, I have found that seal. Malkhana register, where they have kept it, no Malkhana register, they should have exhibited Malkhana register, showing that at such and such time, such and such packets were entered. And at such and such time, such and such packet were exited. Nothing, at least examine the Malkhana in charge who will say that yes, I was the Malkhana in charge. It was deposited in the Malkhana on such and such date. No one. The person who carries the contraband from the police to the FSL, admittedly not there. How do I link it, my lord? How do I know this is the sample which has reached the FSL? It is only the connecting link is this gentleman. All these things will only lead to an adverse inference under section 114G of the Indian Evidence Act. Now, my lord, there are
Half an hour.
আমি জানি না।
Biswa,
my lord.
the seized contraband was sealed before the magistrate
My lord,
and was sealed at CDM Bombay.
my lord,
Handed over to the IO.
my lord.
Now IO sends it to the FSL.
My lord.
Can the IO could have put the superintendent of police, can it be changed later?
It's not there in the evidence, my lord. I'll go by the evidence on the, but that's not there in the evidence. Then they should have said it before the court. I'll cross-examine them. The evidence says the only seal is CGM Bongaigaon. That is the evidence before the court. What had fallen from lordship could be a logical thing, but for that it has to be there somewhere in the evidence. The IO should have said it, that after I have, after the samples were collected from the office of the Chief Judicial Magistrate, I have affixed another seal, Superintendent of Police, then there is a link evidence, but that we cannot supplement. At least I could not find, my lord, subject to correction. From the evidence I have read before the court, my lord, nobody stated,
Not in evidence.
not in the evidence. And Malkhana register not there. Who can? I could have understood if the messenger would have been examined. If the messenger would have said that yes, this is the sample which I have collected in connection with Bongaigaon PS case number such and such from IO on such and such date. And this is the same sample which I have deposited to the FSL on such and such date. There is a connection. But this man is missing. Calling for an adverse inference under 114G. Because if he would have been examined, he would have deposed against the prosecution. Therefore, he was withheld. Evidence Act. Section 114, my lord. You don't bring evidence act during criminal trial. That evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. That is the presumption under the law. The Malkhana register, they could have produced, they have not produced. Therefore, the law says the presumption is that if they would have produced it, it would have been unfavorable to them. Therefore, they have withheld it. The Malkhana in charge, it was their man. It is not that they will have to go and issue a bailable warrant, non-bailable warrant to secure their attendance. No, it is their police station, their Malkhana in charge. They could have produced him. They have not produced him. 114G. All this evidence cannot be supplanted by, my lord, lacuna in defense lacuna or suggestion not made by these lacunas will has to be filled up with affirmative evidence, my lord. And that is the precisely what I have submitted, my lord. I can take a lordship to those judgments. It is the Supreme Court has time and again says the more stringent, that is the principle of interpreting a stringent law, my lord. Your lordship is aware that the more stringent the provision, the more strictness of proof is required. Because, my lord, this is a case your lordship will see. There is no power of, there is minimum sentence of 10 years. Minimum sentence is prescribed. Section 37, during investigation bail. Not, this man is behind the bar since, what forwarding report to? He was arrested on 8/11/2021. Since then, this man is behind the jail. And this is the investigation. So with all this, my lord, on 8/11/2021, this man was arrested. There are many more lacunas in this case, my lord. If we see the report My lord will kindly take the NDPS Act for a while, my lord. NDPS Act. My lord, the provision for search and seizure starts from section 41. My lord will kindly come to section 41. Section 41 is search and seizure in general. Section 43 is before search and seizure in a public place. Where is my book yesterday where I have marked? No. Subsection 3, section 41, power to issue warrant and authorization. Subsection 3. Only the person who is authorized shall have all the power of an officer acting under section 42. Only the authorized person. So the authority has to precede the search and seizure. This requirement of authority is dispensed with if the search is made in a public place. But if it is made in a closed room with a prior information, then this has to be followed, my lord. Page number? Page number 44. Page number 44.
You reading from which section? 41.
Section 41, subsection 3. Subsection 3. The officer to whom a warrant under subsection 1 is addressed, and the officer who authorized the arrest, and the officer who authorized the arrest or search of, or the officer who is authorized under subsection 2 shall have all the powers. So all the powers to search and seizure is vested on a person who is authorized under this act, or to whom an authority is given by the person who is authorized under the act. Now here is a case where the authority is given to a person by a person who is authorized under the act. So this authority has to precede. That is why, my lord, they are playing safe game. 21 they have not written the time. And they have not mentioned about all these things before the IO. These are all they are trying to develop the case in the court. That is one of the ground, my lord. Page number 44. My lord will see page number 44 once, my lord. Now, my lord, page number 44 is an intimation to the superintendent of police by the IO of the case. Now, this intimation is done as per the mandate of section 57 of the section 57 of the NDPS Act. Section 57 of the NDPS Act mandates that after the seizure, within 48 hours, you will have to report to your superior officer the search, seizure and everything. My lord, will see on the right hand side, there is an overwriting on the date. 21 was typed and then by hand it is made as 22. My lord, have seen that? So, my lord, they have, in fact, my lord, this entire case was developed later on, my lord. There is no consistent evidence, my lord, to connect the accused with the recovery, my lord. And, my lord, we are not even certain whether the FSL report pertains to the seizure made in this case or not. That is sine qua non. Suppose, for example, because they use the word suspected. Now, this is very correct. Some people will use the word suspected because they are not FSL. So they will always say suspected unless and until it is being tested by the FSL. Now, I suspect something to be a ganja. Subsequently, it turns out to be a dry leaf, some tea leaf, dry leaf, some jungli patta, something comes out in the FSL. I do not know, my lord. So should a man be behind the bar for some jungly patta, my lord? I do not know what is there. That is the very purpose of sending it to the FSL. Otherwise, if the IO would have been the competent person, then there would not have been any requirement for FSL. And therefore they say, and correctly, my lord, in my understanding, they say suspected ganja. Until the FSL report, they will always use the word suspected ganja in all the cases. And in my understanding, subject to correction, probably that is the correct way of addressing. Because they are not the authority to say whether that is ganja or metamorphine or cocaine or morphine or something. They are not the competent authority. It is for the FSL to say. That's my for 389, my lord. And moreover, my lord, he has no antecedents as well, my lord. And he has been behind the bar for so long, and he's a local resident also, my lord. If your lordship is willing to hear the appeal today, I have almost argued, my lord, only one or two judgment I'll rely, my lord.
Practically, you have argued the whole. Appeal.
Absolutely, my lord. To save judicial time, my lord, this argument may be constituted as my final argument as well. Only few judgment I'll rely. I'll show those, my lord.
Yeah.
He should first make it clear whether he had done hearing or he had moved the 389 application.
Whatever.
Hearing that will
Whatever
take
is-
some time, so
No, no,
perhaps this is 389. So as far as first argument is concerned, that this was not the things that were recovered and the FSL report was something else. Lordship, instead of going into the facsimile, because facsimile may not be the decisive factor in all circumstances, Lordship will go to the letter by which the items were sent for FSL. That he has annexed. Lordship will go to page number 46. Only some changes in FSL will not decide the entire issue. It's page number 46. This was the letter by which it was sent for FSL. Lordship will see here the facts of the case numbers, all tallies with the instant case. Only the facsimile number is something different. Lordship will see the subject matter. Subject matter, prayer for examination of seized exhibit and expert opinion. Then, sir, I have the honor to forward herewith the below noted exhibits for favor of your kind information. Lordship can skip that. Brief fact of the case, brief of the case. On 22/5, the complainant Kujendra Hujuri lodged an FIR. He is PW5 here, Kulendra Hujuri. He lodged an FIR stating that on 21/5, based on a secret information, the complainant along with staff recovered 1 packet cement bag, yellow color, containing suspected ganja and 9 numbers of polythene bags containing suspected ganja weighing 25.563 kgs from the house of Bonamali Sarkar, hence the case. He talks about the instant case. During investigation, IO seized suspected ganja as per Caesar list measuring 25.563 kgs and prepared the sample of suspected ganja weighing 25 grams in 3 packets in presence of Honorable In-Charge Chief Judicial Magistrate Bongaigaon. This is also very clear that the sampling was done before the CJM Bongaigaon. Thereafter, Lordship will see the chart. Suspected weight ganja weighing 25 grams seized by Kulendra Hujuri. This is PW5. Bongaigaon Police Station case number 451. Case number is also is there. This is in respect of these suspected ganja that was recovered from the house of Bonamali Sarkar.
No, that's fine.
Lordship.
Fine. This letter says it's pertaining to this particular case, is pertaining to the seizure made from this person's house, everything.
Hmm.
The facsimile,
Huh.
which says CGM Bongaigaon,
Hmm.
and the product that the FSL got,
Was
Superintendent
superintendent.
Bongaigaon.
But then Lordship,
Now, how do we know that this is the material that was sealed in the presence of the CGM?
Lordship, because the covering letter itself says that these are the materials which were sent for FSL, where sampling was done in presence of Chief Judicial Magistrate Bongaigaon.
No, that's fine.
Yes,
Exactly
in
was
respect of
done.
this case.
It was sealed
Hmm.
in the presence of CGM.
Huh.
Now, if in the midway, if there's a turn of events or there's a change of materials or change of exhibits,
Hmm.
when it was CGM Bongaigaon,
Hmm.
how did the FSL got Superintendent Bongaigaon? This is the issue.
Yes, Lordship, what I would say is,
No,
Lordship will read both the letters that were sent to the FSL as well as the FSL report. And come to a finding whether this is the same one.
No, letters is fine.
Letters is
Or-
fine, Lordship. So here there are no dispute regarding that this was the material which was sent. Why this letter?
By this letter.
By this letter.
CGM Bongagan
Huh.
was sent.
Then Lordship will go to page 48. There also the authority letter. Here there is an authority letter to break the seal. This is given by certified that the Directorate of FSL, Kahilipara is authorized to break open the seal. This is by Superintendent of Police.
Yes.
This is by Additional Superintendent of Police. He gives an authority letter that Directorate is authorized to break open the seal of exhibit sent here.
Which,
With in connection with 451 under 20C.
which seal?
Yes,
Which seal?
open the seal of the exhibit sent here.
No, that's why. Which seal?
A seal of the exhibit that was sent along with the covering letter.
CGM Bongagan.
CJM Bongaigaon. And here SP writes it.
Yes, that's fine. Okay, let us assume
Yes,
till the SP wrote the letter.
Hmm.
Is CGM Bongagan.
it's CJM Bongaigaon.
Now, when the material reached the
Hmm.
FSL,
Yes.
how did the name change?
In fact, Lordship will again go to the report of the forensic science.
Yes.
From the next page, from the director comes special examiner of the government of Assam. This comes to the additional superintendent of police. Now here he sends it to SP again. Please find here with the enclosed report of so-and-so in connection with Bongaigaon PS case. Now everywhere it is written 451 of 21.
No,
There
that's,
is no change as such.
that's fine. That one is okay.
That
We're
one is
we're
okay.
talking about the exhibit,
Hmm.
the material.
Yes,
Let us see the FSL report.
yes.
Where was that? I saw it somewhere.
FSL report,
The report is, he has
49.
not,
page 49, 49.
no, 49 is the
49 is the
authority.
FSL report.
Oh, yes, yes.
Yes,
49,
read this.
yes. To the additional, your memo dated 23/5, so this also tallies 23/5. Advising the examination of one parcel per messenger which was received in the office on 24/5 in connection with case number 451.
Yeah.
Bongaigaon under section so and so.
That was all right.
Same 451, for mode in which the parcel to be packed on receipt, the description of the seal. The parcel consisting of 3 exhibits enclosed in a sealed envelope cover. The facsimile is superintendent. What I can say is superintendent had sent it. Superintendent got it from the letter was sent to first superintendent. And then yes, a letter was first sent by superintendent to the director of FSL, wide 46. Sealing was done in front of the CJM Bongaigaon. Superintendent sends it to the director. And superintendent gives an authority letter, you can open. Now, perhaps that superintendent, there was another facsimile where superintendent comes.
Superintendent examined.
Superintendent,
No.
of course, is not examined, but prima facie.
Was
I
the
don't see any-
messenger also examined? This is the issue.
Messenger was not examined,
The
they did not
messenger could
feel.
have said, yes, I got this.
Hmm.
When it went to so and so, when I took it out, it was this.
Yes.
Then that connection comes.
Yes, then would have been established more. But here, there is nothing to suspect that in between there was some change because same things went, same thing superintendent had sent a letter. Same case number, everything is same, 3 packed envelopes, A, B, and C. And superintendent sends it. The copy of label attached to articles contained in the parcel, the articles were labeled as per copy forwarded. There is again a question of copy of label attached to the articles contained in the parcel. The articles were labeled as per copy forwarded. 3 sealed envelopes marked as A1, exhibit number B1, C1 respectively, each having a closed polythene packet containing 25-gram dry plants in each marked as so and so accordingly. The other contents are all same, only the facsimile, and that too, I have a explanation because superintendent had sent it.
That is the missing link.
But then,
That is the missing.
yes, it can be seen during the time of hearing, there will be more materials in the LCR. We can, or his messenger, if his statement was recorded by the police under 161, that can also be seen. Charge from this, sir.
Can we have it without the paper book?
My lord, if your lordship feels that this paper book can be verified by the registry, my lord, there is only one exhibit which I could not find. I have written it in my index. The lordship may get it verified, my lord. I do not have any objection, or let the registry also prepare a paper book. I was just facilitating the court because on the last occasion when it came up before the Honorable Chief Justice, my lord. So there were some papers were here, some papers were there. So I thought it would be, I have even given a copy to him that the one exhibit I could not find. So that exhibit, one exhibit is not with me, and the one I have already typed, and one is in Assamese. The Assamese is the GD entry is in Assamese, my lord. I'm not, and the GDNC and the charge sheet. Charge sheet also, my lord, I'm not making any substantial argument on the charge sheet. Charge sheet is just an opinion of the IO, my lord. So, my lord, it is subject to your lordship. As far as I am concerned, my lord, my only apprehension is that a man's liberty should not be snubbed, my lord.
No, that's why we are putting that question.
Yes.
You will
And
consider
One more,
that the-
just if one liner, my lord, with all what the worthy counsel for the my lord, it is always a pleasure arguing against Juliba, my lord. Juliba is referring to the learned PP is referring to the
I know her as Jahan.
Jahan, my lord.
Yes.
I know him as Juliba because he was in my first chamber which I joined, he was my immediate senior.
We are all Mr. Mishra's product.
So, my lord, the learned PP is relying on a letter, my lord. My lord, we are not on the letter. It would have been a separate case if we are examining some handwriting in a letter. The letter is immaterial. It is the material which is material. Letter may say so many things. It is the material. Your lordship has correctly asked, my lord. Even, my lord, I am sure, my lord, with the fairness she does her cases, my lord. Even she at the heart of her heart knows that there is a big missing link.
Now, materials, lordship, the trial court will see. It's an appellate court. So we are all with the covering letters and all. So we have to see those documents.
Materials in the sense, the
Now-
specimens. The evidence, I'm dissecting the evidence.
As far as other evidence is concerned, tire, lordship had seen that. But in the tire, only the cement bag was there. 9 packets were found in the adjacent room behind the house of the appellant. And the independent witnesses, what they said in cross-examination is that we have not seen from where it was recovered, meaning thereby that from particular place. Otherwise, they were in the house of Bonamali Sarkar. They were in the front. One of the witness said, I was in the front of the house and I've seen the police taking out the recovered items. They had not gone to that adjacent room. They were in the house, in the compound, in the front part, and they had seen police recovering.
Lord,
But that will not make the independent witnesses unbelievable. It was recovered. Wife and the daughter opened the house and it was recovered from an adjacent. 1 bag from the garage, from a spare tire. Otherwise, it was inside the house. He cannot say that he lends the vehicle to some company and then they had brought the vehicle and it was lying there. He has nothing to do with it. That argument he cannot take because 9 articles were there inside his house. As far as those things not stating to the police, it is not like, unlike other cases where laymen, they speak something to the IO and they say something to the court and the contradictions are proved. Here is a case where police is the informant. Entries are made in all the
The
GDs,
issue
general
here is
diaries.
this. Let us assume that it was from the house. 9 packets from inside the room,
Mm,
1 from the spare tire,
mm,
10.
mm.
That also was tempered.
Tempered, there is no materials because witnesses were there. They
It was
had
made in the
simply,
tree
yes.
before
they-
it reached the CJM's court. It was made in the tree.
But none of the witnesses has said that something was done. In front of them, it is written. that it was transferred from those bags to 3 bags and 3 bags
Now,
in
we have
these.
to study whether the law permits that. That's
Uh-huh.
the whole thing.
That of course.
My lord,
But tempering word as such, we cannot just read it.
No, we're just saying it's been
Uh-huh.
tempered on the sense that,
Yes.
but you will see whether the law permits
Yes.
such a thing to be done.
That
That-
has to be
whether it
against
Can
it.
be done like that.
That I'm
before
not
it-
aware of.
Before it reaches the CJM's court.
my lord. Why we needed witness of seizure? They are witness of seizure within inverted comma, my lord. I'm accentuating the word seizure. They should see the seizure from a particular place. They have not come here to see some commotion or nothing of that sort, my lord. It is no match, no cricket match going on. The point is whether they have seen the seizure from his place. They say we have not seen it. How we can put words into their mouth, my lord? That probably they were in the front side, probably back side. They have seen, but they have said not. My lord, I will go by the evidence on record, my lord. Emotions set aside, my lord. The evidence on record say in clear, and luckily this is in English. This is not in vernacular. So there is no chance of some grammatical variation when it got translated. In clear English language, it is recorded. Well, I have not seen from where police recovered the suspected ganja. How would I read or how would I understand this sentence in English, my lord? They have not seen the recovery of the suspected ganja. Page number 4. PW2. PW1 says, I have not seen from where police seized the ganja. How can we say that he has witnessed the seizure of the ganja? Page number 2, first line.
So, then Biswas, what do we do? We rely on this, Jahan, on this
Lordship,
paper book.
Lordship, yes. I think LCR is here.
LCR is here, your lordship.
LCRs have been missing.
Uh-huh. LCRs are,
Have you gone through the LCR?
no, we can go through during the Lordship, perhaps have not heard the entire matter. So LCR I'll go through during the time of hearing. Without the paper book,
So for the hearing, then we'll fix a date,
Lordship.
maybe next week or so.
LCR is here.
I'm obliged, man. I'm obliged.
Then you can't prepare it with all your adjustments.
Absolutely. Then within a week, your lordship is
Yes,
disposing of, because we have already, your lordship has already had it. I'll cut it short. I'll rely on the judgment because already I have on the facts of the case, already I have made my submission. On the specific law and the judgments, I'll rely before this court. I'll on the next date fix. Only my only if it is because it is not, it is 2020, Kiman, when? 2020.
Lordship, on the other occasion, I said Gurbakh Singh says that these are directory. 52A. 52A, 52 includes 52A. 52, 57. Those provisions are directory.
Singh
I'll
is-
place those
Oh,
judgments.
Gurbakh Singh is outdated. Now latest is Mohan Singh holding the field.
Still followed.
Now the holding the field is Mohanlal. I'll place all this.
That will study.
Lordship.
That will place
We will
it.
place those.
Now, my lord, what I'm my only liberty that I'm seeking from this bench is that, my lord, if your lordship fixes it in the next week, it might come down the list. I'll make a prayer in the morning for upgradation. Only that much, my lord, because I'm not on bail, my lord. So for the bail, your lordship will keep it in abeyance. Your lordship will not pass any order, my lord, in bail. Probably. Your lordship will not reject it as well. Your lordship will keep it in abeyance. Because otherwise, if it rejected, my lord, and the hearing is not concluded within, then again, I might have to renew my prayer for bail, my lord.
Should we rely on this?
Lordship, yes, I'll check it up. I'll cross-check with the LCR and then
Absolutely. That would be a better, my lord.
Lordship
Cross-check.
will hold this. I'll check the LCR and I can proceed. We can proceed.
Because I have given a copy to her also.
I have a copy.
Heard them Biswas, then we counsel to the argument as well as Jahan and addition to the Assam. So. Leonard Counsel for Appellant has prepared a paper book for early disposal of the matter,
Barring one exhibit.
barring one exhibit. Stop. The said paper book is accepted by MS Jahan, Leonard addition. Accordingly, the preparation of paper book by the registry is dispensed with, and the matter be listed for hearing on
Next week. Next week.
Today is 23rd, Nikki. Today is 22nd. No. Today is 25th. So 2nd of June,
2nd of June is Friday.
1st of June,
1st of June.
we'll have extended time. quotas. Oh, no. 1st of June?
Yes, whatever you said, subject to your convenience.
1st of June will be little early, I think. 6th of June,
I move now, but
I'll take out those judgments whether
1st of June because.
it can be shifted to bags.
6th June.
6th June? Habo. To your problem.
I'm okay. 6th June.
Otherwise,
But 6th
Lordship
June
will
is not
forget the
possible. I'll be
facts.
in Arunachal, my lord. 6th June is not possible.
Oh,
6th June is.
8th.
8. First, my lord. 1st of June will do it. Okay, no, I will help you. My lord, she has all judgment in her repository.
no, I'll have to find out whether it
1st
can
of
be
June,
shifted to bags.
Sure.
No.
My lord has kept it part-heard, my lord, because I have already argued the facts, my lord.
No, no, not part. You, like you said, you can agree for updating.
9 of supplementary list ordered.
Yes, Your Lordship. Lordship will recall there is an interim suspension of the sentence of the appellant by order dated
This
25th
is
of
item 2.
item 9,
Nine.
orders.
Oh.
Orders.
Product.
There is an application under 389 for suspension of sentence. And there is an interim suspension by order dated 25 for the Honorable Court was pleased to grant interim suspension of the sentence against the appellant. And Lordship, the grounds some of the grounds which were cited were immediate grounds. The issues concerning his son, his illness, as well as other issues. And also he was required, he is in need of funds and he had certain bills to be realized for the work he has done with the APDCL and to pursue for realization of these funds. Those were the immediate grounds that was in consideration for granting interim suspension. And Lordship, how the
What is your ground for this?
Lordship, as it is on the last occasion I submitted, Lordship, that we'll be arguing on merits. Lordship, of course, my learned my learned friend will, as it is on the last occasion also, today also she'll be submitting that once this has been rejected earlier, in the first instance, this has been argued on merits, so it cannot be drawn into again on that grounds. Fresh grounds need to be cited. But Lordship, even considering merits aspect, one when goes into the merits of there may be several grounds, 5, 6, 7, these are the merits on which we are arguing. If those on the grounds cited by the Honorable Court, on which the grounds the first application was rejected, has not taken into the basic issues, basic reasons which on basic grounds on which our application under 389 has to be considered. Even that, if that has been overlooked, probably in my humble submission on merits, that can be. Here, what has happened, the judgment, it strikes at the basic proposition of criminal jurisdiction of proof beyond reasonable doubt. Prima facie, without even going into the evidence, if your lordship, I can take your lordship to various aspects of the judgment where it shows that the learned court below has in a very, the word I have to use is casual, in a very casual manner has this convicted the appellant here.
So
Lordship, we
why
have
is
also,
it coming up today?
Lordship, as it is the 1 month time of that has expired. That is why, Lordship, either it has to be extended or it has to be rejected, whatever it is, Lordship. That is why I'm praying for consideration on
So
merits.
last occasion was that your son was appearing for his exams
Yes, we have.
and he had some neurological issues.
Yes, yes. We have also filed an affidavit, how I have spent, at least how I have spent the 1 month. I have used the 1 month. We have to bring it to the notice of the Honorable Court. We have filed an affidavit stating those facts. He had got his affidavit, which we have filed yesterday on record. Lordship, the medical examination of his son has been conducted, and the reports, the first instance, it shows there are no such positive indication of the any serious illness. But being the father, as it is, the son still suffers from some epilepsy-related problems. He desires further treatment of his son. And for that, again, the funds will be required. And he has yet to get the payments for the bills.
Bill payment, this is not a material.
Lordship, that is again
We
linked
gave-
up. That is,
was linked up.
yes,
In the meantime, we said you can pursue your bill. But the main issue was that your son was sick.
yes,
Now,
He-
on the affidavit that you have filed, we
Yes.
see that he's not very serious.
not
let's say-
serious. It does not appear. Does not appear.
No, you
The
surrender-
reports.
You surrender, then we'll consider the main criminal appeal.
Lordship, if I may just take your lordship to the certain, there are certain observations at least, aspects of the judgment as I had submitted. Prima facie, it's apparent, lordship, there, it strikes at the basic proposition, proof beyond reasonable doubt. Even lordship, the informant who had, there appears to be two informant.
No, give us a cogent reason. How do we extend this bill today?
Yes,
That is the whole thing.
yes. Lordship, as I have already submitted, the first batch of tests which have the results of which has come does not indicate any serious illness.
Correct.
That is why we have enclosed it. We have not manufactured anything, but the problems which led to his examination still persist. We have stated here in his affidavit, but he is in the midst of his he is about to write his first term examination. We have enclosed the routine also. We've enclosed the routine. It's going on, no? It's going on. Presently, it's going on. We have enclosed the routine at page 74, serial number 74. Yes. Page 74. From 19th of May, he's right. Last time. Yes. And it will be completed on 1st of June. 1st of June. So he desires that after he completes his exams, he wants to go take his son for further examination because the problems still persist. We have stated in our affidavit. He has some seizure disorder. That is why these tests were advised by the doctor. And he's in his 10th standard. He'll be writing his board exams also. For further lordship medical examination, if this can be extended for some further. In the meantime,
What is it? Yes, yes.
Lordship, can it be this way? May I submit? Lordship, considering the illness of his son, as he desires for some further examination, we have stated in affidavit that the problem still persists. For some time, this can be, if this can be extended, and in the meantime, we'll prepare the paper book ourselves, and this can be taken up for final disposal.
No, in fact, 1 month's
You have
time
no
was
problem.
given to him to take care of everything. That is, I think, more than enough in my humble submission. And moreover, the
Think
uncle
about the
is
son.
there.
Think
One
about the son.
uncle of the son is there to take care of him. Son is also not very young. He is in 10th standard. So the
He's a
normal procedure as of date now, what I submit is let him surrender, and married twice, lordship has already rejected it once. Every time new councils will come and better councils will come and say, no, this was not considered. That cannot be the procedure here. So merit wise, it was already dismissed once. So the only recourse would be let him surrender and the hearing can be taken up.
Lordship, I have made a very reasonable survey. I think I never thought the learned PP, she herself is a very
Okay, I made
reasonable
some-
person. She'll object to that. 1 month, Lordship, 1 month, just extension for 1 month. He'll conduct his Lordship further test on his son, further examination. And in the meantime, we'll prepare the paper book and let
And
it
he is
come up
not
for
very
final
serious.
disposal.
Had this been the case, each and every convict has to be released. His son is
No,
suffering.
no,
That
Lordship,
is not-
let us not compare with others. They are not before us here.
He is not very serious as
No,
the
no.
affidavit shows. So let him surrender.
no,
We can
Lordship.
hear the hearing.
He is in his 10th standard without the care of his mother. And relatives, Lordship knows how it is.
That happens to everybody.
Yes, everyone has problem.
But still, Lordship,
We were more concerned for your son's sickness.
yes.
Now the medical report indicates that more or less okay. Maybe he has some case of epilepsy, that's why that DPP is given.
Lordship knows how it is with medical. He has performed those tests at Sipsagar. He desires that he brings his son and gets him medically examined here at Guwahati. Somewhere better, Lordship.
The uncle can do, and in case in between
No,
something
no, no,
serious
no.
comes up, then she is always at a liberty to file an application.
Again, a fresh
But
application.
as of date, as of now,
Lordship, 1 month we'll prepare the Lordship, I'm not trying to delay the matter. We'll prepare the paper book, Lordship.
No, no, that's fine. We are not on that issue. We are not saying that we are trying to delay. it. But then I think you should start,
Lordship.
you should start. Then if some problem comes up. After that, you can again move in application. In the meantime, we'll get a paper, you can prepare the paper book. We'll proceed.
Lordship, surrender.
Till the last-
Just one opportunity, Lordship, for advanced treatment, some sort of an advanced treatment, because he's in the 10th standard, Lordship. That is the whole problem lies, Lordship. 10th standard, and the problem still persists. That is where everything, problems still persist. Seizure disorders. 6th, Lordship, the 1st of June, he'll be completing his exams. We have enclosed the routine, 1st of
That we have
June.
seen, that we have-
After that, Lordship, he wants to bring his son for some advanced checkup treatment here, at least in Guwahati. Lordship, that opportunity may be granted. I don't think she'll object to that.
we are always for the child, but then if something
Not
serious comes up
somewhere
as
outside the
for sake of
country or somewhere
repetition.
outside the state. He is not in a position, he cannot afford that. At least here in Guwahati somewhere, he wants.
Always out of the jail.
Stay. 3 weeks. 3 weeks. 3 weeks. 3 weeks. 3 weeks. No supervision.
Is it a abortion? Why is it? What is abortion?
Public money is क्या करो? Even if you give enough पैसा,
Government पे default.
public money क्या है इसको?
Even as I believe.
Is it for that? Yes.
Lordship.
Jahan,
Lordship,
you stick,
Lordship.
what do you say?
I still stick to what I have just said, that if anything serious comes up, we
Yes.
can always
I
find an
think it's
application.
better that way. Well done. We are passing order in the criminal appeal
Criminal appeal, Lordship.
for the.
We'll prepare the paper book, Lordship, that permission may be granted.
Yes. Then it comes to the appeal. That for stupid disposal of this matter. She may be allowed to for the. It will be verified by the registry.
Lordship,
It will be verified.
Verified by the registry.
yes, that will be verified by the registry.
Verification by the. Okay. Same is not wrong. By Mr. Jahan, by Mr. Accordingly, then it comes to the application. Permitted to prepare the application. Which shall be verified by the registry. Para. The temporary suspension of sentence for a period of 1 month, which was allowed by this court by the order dated 25 for the fingerprint issue expires today. The appellant is therefore direct to surrender. Surrender before
Lordship,
the-
the session just.
not
Lordship.
Superintendent
Uh,
of Jails,
Chief Police Station.
superintendent of
it's
jail.
state,
Superintendent of
No.
Police.
Tinsukia. For truth. Our liberty is granted to the applicant to approach this court in future. No, not.
Lordship, that liberty may be recorded, Lordship. In case of Lordship, that
Our liberty is granted to the applicant to approach this court for suspension of contract. If the condition of the son of the worsens. If the health condition of the applicant, son of the applicant, worsens. List the matter again on after, how long will it take?
within 3 weeks, we'll try to submit.
Ten of supplementary list, part of hearing.
I've almost concluded my argument. He was supposed to give some judgment.
This matter already your lordship has heard that 164 statement of the accused was recorded on 16/7/1997, but the formalities which were done on 1997 lordship. So that cannot be relied on lordship, because if the conditions of 164 CRPC subsection 2 is not complied, then confession goes lordship. Just I'm relying on one judgment. Paragraph 31 to paragraph 36, lordship. Paragraph 31, lordship, just I'm reading. We left with only the statement recorded by PW18, the judicial magistrate, in exercise of power under section 164 CRPC. The relevant portion of exhibit 27 reads as follows. So I'm skipping that part, lordship. 32. No doubt, it is a categorical confession of the guilt of the accused, but the accused went back on the confession at the time of the trial by pleading not guilty in his examination, both under section 228 CRPC and also in his statement recorded under section 313 CRPC. Same is in my case. Therefore, the conviction cannot be based straightway on the confession contained in Exhibit 27. Whether the same can be legally used for any other purpose or not is to be examined. The submission made by the learned counsel for the accused is that PW 18 did not faithfully follow the principle established by law for recording confession under section 164 CRPC, and therefore the same should be totally ignored. Paragraph 34, section 164(2) of the CRPC prescribes the procedure that is required to be followed by the magistrate recording a confession. It reads as follows. The magistrate shall, before recording any such confession, explain to the person making it that he is not bound to make a confession, and that if he does so, it may be used as evidence against him, and the magistrate shall not record any such unless, upon questioning the person making it, he has reason to believe that he is being made voluntarily. It is being made voluntarily. Under subsection 4 of section 164 CRPC, the magistrate is required to make the memorandum at the foot of the statement, the content of which is stated in the said subsection. Subsection 4 of 164 CRPC reads as follows. Any such confession shall be recorded in the manner provided in section 281 for recording the examination of an accused person, and shall be signed by the person making the confession, and the magistrate shall make a memorandum at the foot of such record to the following effect. I have explained to that so this form is there that has to be explained. And in paragraph 35, Lordship, one judgment of Honorable Apex Court is relied on. Does Honorable the Supreme Court in AR so and also effect of non-compliance with any one of the requirement of section 164(2) and held as follows. On a consideration of the above decisions, it is manifest that if the provision of section 164(2), which required that the magistrate before recording confession shall explain to the person making confession that he is not bound to make a confession, and if he does so, it may be used as evidence against him. And upon questioning the person, if the magistrate has reasons to believe that it is being made voluntarily, then the confession will be recorded by the magistrate. The compliance of section 2 of 164 is therefore mandatory and imperative, and non-compliance of it renders the confession inadmissible in evidence. Section 463, old section 533 of the Code of Criminal Procedure provides that where the questions and answers regarding the confession have not been recorded, evidence can be adduced to prove that, in fact, the requirement of section 2 of 164, read with section 281, have been complied with. If the court comes to a finding that such a compliance had in fact been made, the mere omission to record the same in the proper form will not render it inadmissible evidence. The defect is cured under section 463, section 533 of the old code procedure, old criminal procedure code. But when there is non-compliance of the mandatory requirement of section 164(2) Code of Criminal Procedure Code, and it comes out in evidence that no such explanation as envisaged in the aforesaid subsection has been given to the accused by the magistrate, this substantial defect cannot be cured under section 463 Code, Criminal Procedure Code. Now, paragraph 36. The learned counsel for the accused relied heavily on the judgment of Supreme Court. Recording that paragraph is quoted, Lordship. From the plain reading of section 164 CRPC and the rules and guidelines framed by the High Court regarding the recording of confessional statement of an accused under section 164 CRPC, is manifest that the said provisions emphasize an inquiry by the magistrate to ascertain the voluntary nature of the confession. This inquiry appears to be the most significant and important part of the duty of the magistrate recording the confessional statement of an accused under section 164 CRPC. The failure of the magistrate to put such questions from which he could ascertain the voluntary nature of the confession detracts to materially from the evidentiary value of the confession on confession of an accused, that it would not be safe to act upon the same. Full and adequate compliance, not merely in form, but in essence, with the provision of section 164 CRPC and the rules framed by the High Court is imperative, and its non-compliance goes to the root of the magistrate's jurisdiction to record the confession and renders the confession unworthy of credence. So this is the main my submission here before Lordship. And if I take your Lordship to the confession again, page 70 in the paper book, and relevant portion, your Lordship, which I am placing is page 73. These questions that I am not an officer, I am not bound to make you are not bound to make confession. Those things that which are mandatory, those were put on 17/7. On next page, your Lordship will find the signature date. And the contents, as I have already pointed out, page 76, bottom, your Lordship will find that contents of the LS confession was recorded on 16/7. So that 164(2) is not complied with, so that cannot be relied on. And the other thing also regarding the evidence of PW2, just I'm placing another judgment of Honorable Apex Court, Lordship. Here, Lordship, paragraph 8, 9, and 10. Because PW2 is the wife of the deceased, and her conduct was not natural, Lordship.
This is not reported.
It is not reported, Lordship.
Oh.
It is of 16th March 2023. Paragraph 8, Lordship, I'm reading.
Yes.
It is a settled principle of law that doubt cannot replace proof. Suspicion, however great it may be, is no substitute of proof in criminal jurisprudence. Only such evidence is admissible and acceptable as is permissible in accordance with law. In the case of a sole eyewitness, the witness has to be reliable, trustworthy, his testimony worthy of credence, and the case proven beyond reasonable doubt. Unnatural conduct and unexplained circumstances can be a ground for disbelieving the witness. So here that unnatural conduct is that she saw her husband lying in the injured condition, because at that time she said he was alive. She came back to inform other person. She did not go back, did not provide any medical treatment, did not inform the police. This is unnatural because her husband is dying. And then Lordship, one judgment of which from our High Court, it went to Supreme Court, that is relied, O'Neill Fukon. So long as the single eyewitness is a wholly reliable witness, the court have no difficulty in basing conviction on his testimony alone. However, where the single eyewitness is not found to be a wholly reliable witness, in the sense that there are some circumstances which may show that he could have been interested in the prosecution, then the court generally insists upon some independent corroboration of his testimony in material particulars. Before recording conviction, it is only when the courts find that the single eyewitness is a wholly unreliable witness that his testimony is discarded in toto and no amount of corroboration can be cured that defect. And then your lordship will find paragraph 9, lordship. That unnatural conduct, because she were after witnessing her husband in injured condition, she went home, she slept, and next day morning she reported the incident. The exact same here, and therefore the evidence of PW3 was discarded by the Honorable Apex Court, lordship. Paragraph 9 I am reading, lordship. In the instant case, when we examine the testimony of PW3, we noticed him to have deposed that on the fateful night, that is 13/1/2002, around 11 p.m., both he and the deceased were sitting on a nala near the circuit house in Surendra Nagar. At that time, accused came on a motorcycle with Soilendra as a pillion rider, and after abusing, wanted Ram, deceased, to state as to when he would return the money borrowed by him. When the deceased stood up to answer, Narendra pulled out a pistol and after placing it on the neck said that this would not take much time to finish you. Thereafter, accused fired the pistol. Resultantly, the deceased collapsed on the ground and started bleeding profusely from the neck. Immediately, Narendra Jala and Soilendra drove away towards the Sardar scooty. PW3 states that the incident left him shocked and stunned. He was so scared that he ran towards the scooty where he met his uncle Harshad Beljibai, PW9, and his friend Manasi Natwarlal Trivedi, PW8, whom he informed the incident. Seeing his condition, he was asked by his uncle to go home and sleep. And in my case also, just I'm pausing here for a moment, lordship. The relevant line I'm reading I'm just reading the relevant line from page 12, lordship. Then I ran towards the house of our neighbor and told them that my husband was lying senseless in the field. Then the house owner took me to my house. So similar is the case in my case. Here also he went there, he informed the others, and he was asked to go home and sleep. Next morning, he went to the house of Ram and narrated the incident to his mother and sister Hinaba Pradeep Singh Jala. Thereafter, he went to the hospital and informed Ram's father of the incident. Police interrogated him at different places and recorded his statement on the 14th day of January at around 4:30 p.m. at the police headquarters. Cross-examination part of the testimony reveals that witness has repeatedly improvised his initial statement disclosed to the police. Illustratively, he had not informed the police of having disclosed the incident to the sister of the deceased. He had also not disclosed to the police that there was exchange of words between Ram and Narendra in relation to some money owed by the deceased to the accused. This may not have any effect on the veracity of his statement. But what makes his testimony shaky and the witness unbelievable is his admission in the police headquarters being in close proximity to the place of occurrence of the incident, and despite knowing that police is always posted at the gate, he did not approach the police. The explanation furnished is only that he was much scared, which prudently is not acceptable given that he was a close friend of the deceased. Further, his credit stands impeached on the cross-examination part of his testimony. The witness is an adult, mature, and worldly, wise. He is aged 24 years and runs a grocery shop. He is not illiterate. Yet he chose not to take any action, even to save the life of his friend. His explanation that he went home and slept is uninspiring in confidence, for the incident took place in his presence and is close proximity of habitation. More specifically, at a short distance, that is just 3-4 minutes of walking distance from the police headquarters, where constables are posted around the clock. He left his friend profusely bleeding on the spot, but did not seek any help and immediately did not report the incident to the family members of the deceased, whose house he visited only the following day at around 8-9 a.m. His conduct of going off to sleep, having seen his friend being murdered right before his eyes, and then not visiting the hospital forthwith is quite unnatural. Also, he did not inform the incident to his parents. It was only when the police interrogated him, he named the accused. His testimony is not free from embellishments. nor is not corroborated by any other evidence. He also he admits not to have, so this is I'm keeping lordship. So basically my submission is that lordship in paragraph 8, your lordship has seen that unnatural conduct and unexplained circumstances can be a ground to discard the evidence of a witness. Here also, if your lordship takes up the paper book, that page 11 is the evidence of PW2. And here also she says that after witnessing that incident, I'm reading that line, lordship. Then I ran towards the house of our neighbor and told them that my husband was lying senseless in the field. Then the house owner took me to my house. Then police accompanied with the uncle of deceased Manik Saha and told me the description of Balia Muria. I did not go to the police to the spot at night. On the next day, police came to my residence and recorded my statement after taking the dead body for postmortem. And if your lordship sees your lordship has seen the evidence that incident occurred 5 to 7, between 5 to 7, and police arrived at the place of occurrence 12:30. And this witness who claimed that she immediately went to the place of occurrence, but none of the neighbor, none of the relative went to see the deceased, lordship, which is quite unnatural. So therefore, her presence is doubtful. And otherwise, if your lordship discards the 164 and her evidence, then everything goes, lordship. And paragraph 14, your lordship will find of this judgment which I have given, lordship, Narendra Singh Kesubhai Jala, that which I have read just now.
Yes.
Regarding that dao which was allegedly seized from the possession of the accused, but it was not proved to be a weapon of offense, lordship. We may observe that save and except for the confessional statement of the accused, the prosecution is not able to link the weapon with the accused. There was no scientific evidence or the marks of his fingerprints, other identification marks, or any telltale sign of the blood found on the body of the deceased, linking it to the metal pellets of the bullet fired from the weapon recovered during investigation. This court has consistently held in a catena of judgment that it is the duty of the prosecution to establish use of the weapon discovered in the commission of the crime. So here it was not proved that the weapon which was seized by the police was used in the commission of crime. Failure to do so may cause aberration in the course of justice. That regarding weapon, lordship, paragraph 14 and 15. And if these things goes, lordship, there remains nothing. This is my humble submission.
As far as 164, I've already stated yesterday, I've gone through I've tried to find out judgments where Ratan Singh is still followed. Because here is a case where the charges and all were framed by Deputy Commissioner. Then the judiciary was not separated. It was separated in 2013. And thereafter, the entire case was transferred to the session judge. That is how it took place. So even the depositions, the confessions 161, they were all at a stage when the judiciary was not separated. Confession was before the executive officer. Now I've tried to find whether Ratan Singh is still followed. In fact, it is still followed. 2015, there is an honorable Supreme Court's order where the judgment was headed by Justice Chelameshwar. And the aspect was of a civil nature. But in paragraph 9 and 10, I've sent the email. I've sent a mail of that judgment. Lordship can just see paragraph 9 and 10 of that judgment of 2015, where it is the Ratan Singh is relied, and it is said, Ratan Singh only it is said that in what extent spirit will be followed in tribal areas. Now, what spirit, which will be followed, which will not be followed. Then in Ratan Singh, the Honorable Supreme Court said it is for the judge to decide which has to be followed and which not. Because people were not accustomed with the rigors of the criminal law jurisprudence. So Lordship, even 2015, Ratan Singh was followed and Ratan Singh was referred. And in that Supreme Court judgment, some High Court judgment was also referred, saying that CRPC in toto is not applicable in tribal areas. So here, the judgment that he has placed on 164, I very well agree. Yes, those has to be followed. And confession can be sole basis, but I'm not taking on that sole basis criteria. What I'm saying is that confession, there are so many flaws. Was it on 16? Was it on 17? Difficult to gauge. So confession, there is a statement made by the accused, and that can be taken as a circumstance. It is not a substantive evidence. Lordship knows confession is not a substantive evidence because the witnesses could not cross-examine. But it can be used as a corroboration, contradiction. So here it becomes a piece of evidence, a piece of circumstance to link the accused to the crime. Lordship can just see page number, paragraph 8 and 9. Here, Ratan Singh only referred, but the particular paragraph I wanted to place it before your Lordship. This is paragraph 8. Lordship will go to paragraph 8 first. It is clear. The portion that I've just said, that it is for the judge to decide which spirit to be followed and which not. Paragraph 8, Lordship can just skip those, not required. Lordship will go to the Ratan Singh's third paragraph of Ratan Singh judgment. A similar attempt. In that paragraph, Ratan Singh is referred, and third paragraph of Ratan Singh judgment I'm placing. A similar attempt.
Yes.
Lordship. Lordship can go to the second paragraph as well. I'm so sorry, maybe excuse. Second paragraph. Laws of these kind are made with an eye to simplicity. People in backward tracks cannot be expected to make themselves aware of the technicalities of a complex code. What is important is that they should be able to present their defense effectively, unhampered by the technicalities of complex laws. Throughout the past centuries, the Code of Criminal Procedure has been excluded from this area because it would be too difficult for the local people to understand it. Instead, the spirit of CRPC has been asked to be applied so that justice may not fail because of some technicality. The argument that this is no more, the argument that this is no law is not correct. Written law is nothing more than a control of discretion. The more there is of law, the less there is of discretion. In this area, it is considered necessary that discretion should have greater play than technical rules, and the provision that the spirit of the court should apply in a law conceived in the best in the best interest of the people. The discretion of the presiding officer is not subjected to rigid control because of the unsatisfactory state of defenses which would be offered and which might fail if they do not comply with some technical rule. The removal of technicalities, in our opinion, leads to the advancement of the cause of justice in these backward tracks. On the other hand, the imposition of CRPC would retard justice, as indeed the Governor General, the Governor, and other heads of local government have always thought. We think, therefore, that Article 21 does not render the rules of 1937 ineffective. These are administration of justice rules. A similar attempt is also made by comparing these rules with the Code of Criminal Procedure applicable to the rest of India. It is contended that this leads to discrimination. We think that exigencies of situation clearly demands that CRPC should not apply in this area. It is not discrimination to administer different laws in different areas. The presidency towns have got special procedures which do not obtain in other areas. We have known of trial by jury in one part of India for an offense which was not so triable in another. Similarly, what is an offense in one part of India is not an offense in another. Regional differences do not necessarily connote discrimination, and laws may be designed for effective justice in different ways in different parts of India if people are similarly circumstanced. These backward tracks are not found suitable for the application of Code of Criminal Procedure in all its rigor and technicality. And to say that they shall be governed not by the technical rules of the code, but by the substance of such rule is not to discriminate this area against the rest of India. Lordship will skip the second paragraph, not required. This is talks of Nagaland. Lastly, it is contended the rule themselves allow for discrimination because one officer may take something to be the spirit of the Code of Criminal Procedure and another may not. This is what I'm stressing on. The requirements of the case must determine what should be applied from the CRPC and what should not. The rules have been purposely made elastic so that different kinds of cases and different situations may be handled, not according to a set pattern, but according to a requirement of the situation and the circumstance of the case. In the backward tract, the accused is not in a position to defend himself meticulously according to the complex code. It is therefore necessary to leave the judge free so that he may mold his proceeding to suit the situation and may be able to apply the essential rules on which the administration of justice is based untrammeled by any technical rule, unless the rule is essential to further the cause of justice. This is what I was saying. So here, Lordship has to see about a reflection time, about some of the mistakes. Reflection, it's written that I have kept him in the custody of a peon and a person who has no interest in the case. So here, those, even voluntariness was looked into, certificate was appended into, questions were asked. Those basic requirements of 164 are there in this confession. Some mistakes here and there, of course. But that is why I'm saying it may not be taken as the sole basis. It can be taken as a circumstance in order to bring home the guilt of the applicant. Here, as I've already stated yesterday, the circumstances. Accused surrendered. He brought the entire incident into light. Thereafter, he was put in the lockup. Thereafter, the in charge came, took him, PW1 as well as PW7 to the place of occurrence where the dead body was lying. Body was recovered as led by the accused. In the meantime, wife reached the place of occurrence upon hearing hue and cry. She saw the accused running away from the place of occurrence with the machete, and it was not contradicted as we had submitted yesterday. She had not stated about the identity of the person in her 161 statement, but that was not contradicted. So if the contradiction is not proved, her statement stands. So she had seen the person running away. She had seen injuries on head and legs. PW7 had also seen injuries on head and legs. The doctor's report said he died of head injury. So as well as coupled with the confession made under 164 by the accused. These are the circumstances which proves that it was the accused because of reason. There is also a motive which comes into light. The water that the accused was not allowing to flow to the other fields. So coupled with the motive and 164, this case is proved beyond reasonable doubt. This is what my submission is.
What I have understood from the judgment, Lordship, which is relied on by my learned friend, Lordship, it is relating to different context. I am on 164, Lordship, whether it is applicable here or not. Just again, I am stressing on one line of the judgment which I have given of division bench of our High Court, Lordship. Just one line I am reading. Full and adequate compliance, not merely in form, but in essence, with the provisions of section 164 CRPC and the rules framed by the High Court is imperative, and its non-compliance goes to the root of the magistrate jurisdiction to record the confession and renders the confession unworthy of credence. That, Your Lordship, paragraph 36, it is there, Lordship. The Supreme Court judgment which is relied on by the division bench. And another aspect is here, Lordship, as I was not placing this because Lordship, already the learned trial court has discarded that 164, and therefore I was not placing. But as my learned friend is stressing to take some circumstance from that, Just I am relying on another judgment of our Division Bench High Court. I have handed it over to the court master, Lordship. That when Lordship, a person is arrested and is brought before the court, before recording his 164 statement, Lordship, he has to give Lordship legal assistance, Lordship. That is that judgment I have given. That paragraph 17 and 18, Lordship may kindly see. The last element, paragraph 17, Lordship.
Oh.
17 and 18, Lordship, I'm reading. 17. The last element is the confessional statement. We have already stated that the accused was arrested on 14th and kept in police custody till 17th. The detention of the prisoner beyond 24 hours was violative of section 57 read with 167 of CRPC. However, the police tried to cover up the illegality by stating that the accused was arrested on the 16th. However, the oral and documentary evidence pointedly show that the accused was arrested on the 14th. Hence, the accused was in illegal detention and the police tried to suppress the fact. Therefore, the police pressure was very much there and there was unexplained delay why the accused could not be produced within 24 hours before the magistrate. This creates a reasonable doubt that the police pressurized the accused to confess. The accused also stated in his examination that he was tortured by police. A confession must be perfectly voluntary as well as true. The burden is on the prosecution to show the two elements. When prosecution demands conviction on the basis of confession, the court must apply double test, whether the confession is voluntary, and number two, if so, whether it is true or trustworthy. Satisfaction of the first test is a sine qua non for its admissibility. If a confession appears to the court to have been caused by any inducement, threat, or promise, as mentioned in Section 24 Evidence Act, it must be excluded and rejected. No question of proceeding further to apply the second test arises. It is the sum and substance of the law enumerated in the Kothugwala. The object of Section 164 of the code read with the judge's rule, that is the executive instructions of the High Court, is to find whether the statement sought to be made by an accused is perfectly voluntary or not. The requirement of observing the mandatory provisions contained in Section 164 and the rules is to find out the voluntariness of the statement. A magistrate, before recording a confession, must make inquisitorial inquiry, make adequate exercise to ascertain as to whether the accused was compelled by any external element or impelled to make the confession. The magistrate must exercise to find out the real motive behind making the confession. If he finds the motive to be well grounded, that is, the prisoner has a real, genuine, and impelling motive to make a clean breast of this crime, the magistrate should proceed to record the confession. We have dealt with elaborately as to the duties of the magistrate before recording a confession in so-and-so as well. We reiterate that the provisions of Section 164 and the judge's rule are safely valved made to muzzle involuntary confessions. It has also been held that said decision that the warnings set forth in Section 164 are merely illustrative and not exhaustive. One of us observed in Kothugwala and Gajendra Burman that it is imperative for the magistrate to explain the accused his constitutional right under Article 22(1) of the Constitution, as well as the provision of Section 303 of the Code about his right to consult a lawyer before recording any confession. It has been held that even at the investigation stage, an indigent accused has a right to free legal aid. The importance of legal aid to an indigent at the investigation stage, and particularly when the accused is produced for making confession, was highlighted in the aforesaid decision. It has been held that failure to provide free legal aid to an indigent is violative of the basic fundamental norms of the justice, and no court of justice ought to act upon such confession. One of the ingredients of fair procedure is providing free legal aid to the prisoners who are indigent and otherwise disabled from securing legal aid. We rely on the observations of the professors Sancho. The stimulating philosophy of legal aid by Mr. Justice Brennan quoted, so that is there, reported in so Article 8 of the Universal Declaration of Human Rights, Article 14.3 of the International Convention of Civil and Political Rights, and extracts from the report of High Power Committee on Free Legal Aid. So that is from where? Then your lordship will find the right of under trial prisoner to the assistance of a lawyer provided at state cost is secured to him. It is the constitutional right of every prisoner who is unable to engage a lawyer or secure a legal service on account of poverty, indigence, or incommunicado situation to have free legal service. In default of compliance with the obligation by the magistrate, the confession is vitiated as contravening Article 21. I reiterate that one of us observing Gajendra Burman experience shows that ordinarily affluent persons do not make confession, whereas almost 10% of the confessions come from those who are economically, educationally, and or socially backward. The reason is not far to seek. The rich get ready-made legal assistance. What happens to a person like the present appellant, a poor little Indian? He does not know his rights granted under Article 23. No person accused of an offense can be compelled to be a witness against himself, nor does he know that there is a provision under Article 22(1) that a prisoner has a fundamental right to consult and to be defended by a legal practitioner of his choice. He is uninformed about the statutory provisions like Section 303 of the CRPC, which provides that the person against whom proceedings are instituted under the CRPC has a right to be defended by a pleader of his choice. The term investigation defined in Section 2H of the Code includes all the proceedings under the Code for the collection of evidence conducted by police. Recording of confessions under Section 164 of the Code is part of the police investigation and falls in Chapter 12 of the Code. Such recording of confession is a part of the police investigation and is a proceeding under the Code. The accused has fundamental rights under Article 23 as well as Article. So here also your lordship will find that the order dated 17/7/1997, that is not there. Whether he was given free that legal assistance or not, those things are also not there. And the statutory provisions which were asked to him, that is after recording of the evidence, recording of the statement.
Only paragraph 9 of the judgment that I have given can be seen, where Assam High Court judgment is referred saying that a CRPC is not applicable to traffic.
You want to have future arguments or you ask them?
That is something different. Here is a case, it's not a case that we are not following the CRPC.
Mhm.
If CRPC was not applicable at that point of time, they could have a different law out there, different procedure.
Those administration of
Now-
justice rules are not.
Now they have followed the 164.
Hmm.
Once you are following, you have to follow it. Left and straight.
Yes. No, in spirit that can be followed. This is what Ratan Singh said.
No.
That it is for the judge to what spirit? It is for the judge to decide in the facts and circumstance.
No,
in
in
what-
this case,
Hmm.
the magistrate,
Hmm.
they have followed the CRPC.
Followed the
They have
CRPC.
not said that since there is another law,
Mhm.
rules of administration or
Mhm.
something like that, the spirit of CRPC will follow. It's
Yes,
not the
yes.
case.
No, yes, that is, I've also
So
tried
once
to.
you follow 164, you have to follow it
But
strictly.
there, of course, there are no administration of justice rules. I've tried to find out whether in Karbi Anglong that part there was,
Hmm.
unless it is applied. But Ratan Singh says CRPC will be followed not in letter and spirit, but in spirit only.
But the issue here is the date.
Date. The
17
mistake is of course there. That is why I'm saying this can be used as a corroboration at best.
Not the basis,
Yes,
not the basis,
not the entire, not as a evidence.
only a basis.
Okay. You want written arguments? Give your written arguments.
Yes, yes, I'll give my written.
How long you'll take?
Day after, oh, tomorrow is Friday. Tomorrow we can get- Tomorrow.
Okay. But Mr. Ahmed, amicus curiae, isn't it? Also, it is done and addition, yes, some hearing concluded, just one is there. You submitted to the bench.
Not
When can you submit,
tomorrow, I'll try.
Ahmed?
By tomorrow.
Obliged.
All right.
Here, what I have a submission to make because Das's case. An analogous debt reference is pending here in High Court. Where cases are different. This is a case where a previous happening is in picture, has been dealt with as far as because does. Then his subsequent action led to a death sentence. And that death sentence reference is pending. So what my submission is, this is an initial act of because does. Subsequent act led him to that sentence. So in a way it is connected. Even 164 statement of because does is recorded in this case was referred in the other case. So whatever your lordship decides, but I think it should be taken up together.
In my humble submission, Lordship, those two things are too different because here I was convicted for an offense when I have committed offense on 5th. I'm just giving the date, Lordship, 5th. In that case, he committed offense on 1st. So that was previous.
Oh,
In
that-
my offense is
that's it.
subsequent.
Oh, acha, then I've
But in
got
that
mixed up.
case,
That
he,
was previous, this is subsequent.
Yes,
Previously, he's given
he
death
is
sentence.
given death sentence, and in my case, life sentence. So both are two different facts, Lordship. Maybe similar offense, but in different district, different facts, Lordship.
But same offense, body is same.
No. Body is different, victim is different. Only the appellant before your Lordship is same.
Body was found in Assam Award Express in the washroom.
No, that is different.
That here was also that subject I found.
I think that is the one here.
That is the one here.
No, here
Avadh
from
Assam.
Avadh Assam Express, one dead body was found in present case. And it was recovered at in Morioni, that is Jorhat district, Lordship. And
This
in
is the
that case,
here.
it relates to Shivsagar district, that offense.
That reference.
Yes, that reference. That is in respect to different case.
This is Morioni.
Morioni.
Yes. Sipsagar is subsequent.
It's
This
subsequent.
is
offense.
Avadh
They had to prior.
This is about Assam.
This is Awad Assam. Then I'll have to see that death reference because once it came. And then we, in fact, on that day only we made submission that there was another
Just
appeal pending and needs to
for
be.
clarification, I am taking your Lordship to 145, Lordship, of paper book.
This is 164,
Yes.
313.
Here your Lordship will find at around 7:30 on 10/7/2018. I came to Simlaguri station from Badarpur to visit. The train which I traveled was Dibrugarh-Rongya Express. So that date reference is in connection with the offense alleged to have been committed in Dibrugarh-Rongya Express on 10/7/2018.
10-7.
That is prior to my present case. And in next page, your Lordship will find
10-7, yes.
in the next page, your third line, your Lordship will find I returned Simlaguri to Dibrugarh by Avadh Assam Express at around 9:50 on 11/7/2018 I came to Tinsukia from work from Banipur station. The vehicle, so this Abbas Assam is on next day. So this is not a subsequent conduct, and because of that, he was death reference was there. It is not that low. Because my case is subsequent.
Yes, Jahan.
But then the accused are same.
Accused is same, that may be, because otherwise also if your lordship see here in the index,
Hmm.
there is 21 PWs are there. 21 PWs, 9 DWs and other exhibits. And if your lordships club it together, it will be clumsy lordship. But I feel lordship, subject to correction. Because this is a separate incident and that is separate incident.
Not question of clumsy, whether it is at all required, we will have to see. No,
The
let me
other-
check up then, because I appear in that red reference also, but
Can
I've
be
perhaps.
taken at a time, but
Uh-huh.
argument and the submission and the hearing can be separately taken
Hmm.
at the same time. Clubbing the both the cases.
And 164, as my learned friend also said, this was applied in that case also.
Yes.
So this will have some effect on the, I think.
Because here what happened, just I'm placing the fact, lordship. The 164 was recorded by a judicial magistrate in Jorhat. And my case was tried in Dibrugarh. And other case was tried in Sibsagar district. But in Sibsagar and Dibrugarh district, both cases, lordship, took the confession or recorded in Jorhat district. Although it was in connection with my case, but it was taken up. Because in that case, the present appellant, he was brought before the magistrate where he refused to make confessional statement, lordship.
That actually cannot be used. Cross cases, evidences needs to be independent. One evidence cannot go to the other evidence. That we'll have to see again. Let me examine the matter. Lordship will give me some time there.
Okay.
In that case, lordship may fix a date, and along with that matter, then other council may also submit whether it is required or not.
Later come.
Together.
That reference number he also had.
4 of 2019.
I'm not passing the order.
That's
you
it.
Study. the
Oh, no.
question. But, I'm not going down this issue. On request, member as Jahan, and in addition to the Assam. Mr. Matter after 1 week.
1 week.
Lordship is taking up with the other matter.
No. Let us study and come back next day.
Lord.
Let us see whether it's required. I'll see.
Obliged, lordship.
3.
Wait, please, Mr. Lawson. My lord, appeal against the conviction under section 302 IPC, my lord. The trial court sentencing the accused person rigorous imprisonment for life. my lord. There are 3 accused persons, my lord. Out of 2, my lord, preferred this appeal, my lord. I am arguing, my lord, for acquittal, my lord, in respect of the Meghnad Patra, my lord. And my lord, 304 part 2, in respect of the my lord Jagannath Patra, my lord.
1 minute.
Ejaha is in page number 3, my lord, of paper. book, my lord.
Lordship, since 3 accused persons are convicted, Lordship, maybe the appeal of another one was for this honorable court might be minor. You have to check
Sonju,
because he's you're appealing for 2, right?
2, my lord.
There are 2 appeals.
No, no,
Three
one
accused
appeal, my
person.
lord. I am for appellant is 2 there.
Jagannath, Meghnad and Sanjay Deori.
I am for the my lord Meghnad and Jagannath, my lord.
The third,
Lordship,
third
I don't-
accused.
I'm not aware about the third appeal.
Sanjay Deori, someone appeal. Yeah, system. Sanjay Deori. Sanjay Deori, where is state of the son?
Name.
Hmm?
Something.
Sanjay Deori.
Meghnad, you are praying for acquittal.
My lord.
And Jagannath,
Jagannath, my lord, for my lord, 304 part 2, my lord. Alteration. 1022.
He's saying this convict, no? Only yeah, maybe a third one.
Pending 9 below 5 mark.
Come back at two.
It did not find
State petition, appeal.
appeal 9. Sanjay BEORIS, I said, Deori.
Just a-
We'll come back at two,
Fine.
meantime you check it up. So along with criminal appeal within bracket J
75.
75/2020. After,
1 week, my lord.
I think they'll require some more time. After 2 weeks,
My lord. My lord, date may be, my lord.
no date, let it come.
Oblige, my lord.
Alright, with regard to item number 7, I'm told the paper book is not there to be public.
Just a second.
Item 7, actually, I don't know, our office person couldn't find out the paper book.
Objection by.
You couldn't find.
Yeah, office must have been served, but then, but there is an I also pending there. I was supposed to file my objection, that I missed somehow.
That has been filed. That has been filed.
Oh,
Yes, yes,
fine. Oh, okay. I filed it, I'm told. So,
You are Mr. B. Prasad.
B. Prasad, amicus curiae in the matter.
Heard Mr. B. Prasad, Leonard Amicus Curie. On request made by S. Jahan, Leonard additional UG Assam. Additional PP Assam. When do you want?
any day, I'll take the photo, I'll do a photo stat, I'll Xerox the
After
copy
2 weeks.
after a week.
My lord, can there be a date, my lord? I am also appearing in this case, my lord. Can you be clear on
Then you say also heard,
30?
heard so and so,
B. Borough
Leonard Amicus Curie. Also heard Mr. B. Barrow, Leonard Counsel
for the appellant.
for the appellant in criminal appeal jail 52 of 2020. Then on request made by so and so.
Can it be on Tuesday, my lord, 30 of June, 30 of May?
We have got quite a lot of numbers.
What?
6th of June.
Sixth
Not
of
June.
June. God bless you.
Six,
I took a copy from Mr. Prasad, sir. Here also, we didn't get the paper book. I can check the case diary and case record, I can do it.
They have not received the paper book, Lordship.
No,
Then you get a paper book.
uh,
Taking from the
Otherwise-
case diary gets a little difficult
otherwise I'll have to see this and do
because the page, will not tally.
page numbers and all.
Third MSRD Majumdar,
Yes, Lordship.
Leonard Amicus Curie. On request made by Jahan, Leonard additional PP Assam. When? 2 weeks.
After a week, I'll take the copy from her.
After 2 weeks.
Much obliged, Lordship.
eight,
Yeah. Nobody's appearing.
Mr. R. Sharma's name is shown, but he's absent today.
eight,
Is he regular otherwise?
Lordship,
Is he regular?
I could not get it.
No, is he regularly appearing?
Amicus curiae.
No, that's why, does he appear regularly?
Yes.
None appears for the other. MS B. Buyan, Leonard additional PP Assam is present. As well as MS. P. Learned counsel, legal aid counsel for the respond number. This up to 2 weeks. Finish. We could have finished this in the first half.